My lawyers don't have instructions from us to proceed in the absence of their leader. I don't know where that leaves us. Because we appointed the Honorable Karua to come from that far. I can compensate the competence, the availability of our current team that we have. But she has a special role for me, I think, that we have had to incur that great cost to get her here each time to follow up this case. And as lawyers have immediately pointed out, she was here and we were ready to proceed. Only that it was not really possible. We are now informed, I was informed at 7 p.m. last night that there is a here that the production warrant has been received. Indeed, so our lawyers, some of whom are not here. So, Your Worship, our lawyers definitely don't have instructions from us to proceed in the absence of our lead counsel.
Our part of the defense team is not here, Your Worship. Reason we got a very short notice because we received the production warrant when it was coming to 6 p.m. yesterday. And the team leader, that is Senior Counsel Martha Karua, had just returned to Nairobi. She was here on Wednesday. We requested the sitting magistrate to accommodate us this week, either yesterday or today, and said the diary of the court is full and that the instruction he had was to adjourn this matter to early June. We did that. He stuck his gun and said there was no way this matter could be would be fixed again this week. So that would have enabled our senior colleague Martha Karua to stay. If indeed Your Worship would have been accommodated for this week, she would be here to lead the team. Now, shortly after she had returned to Nairobi, they will get summons, rather production order. And to make matters worse, Your Worship, we don't know why we are here. We have no idea. We could not even prepare anything. This ambush, totally unacceptable, Your Worship. We don't know how court was moved, because there must have been a formal application to move court to issue a production order, either by a letter indicating the reason why court should be convened today. Because the matter was adjourned to 29th next week. So Worship wanted to be on record that particular matter, that this ambush is totally unacceptable and we take exception to it. Related to that, Your Worship, again, the atmosphere in the court is not conducive for dispensation of justice. Your Worship, under Article 28 of the Constitution, one of the key tenets of fair trial is public hearing. Public hearing. But the atmosphere, the whole environment here, Your Worship, is not in any way concomitant with the dispensation of justice. On Wednesday, Your Worship, we struggled to get at least an opportunity for the loved ones of the accused persons to have an interface, an interaction. Even after it had been granted, we had to go through rigorous processes of realizing that constitutionally guaranteed right of access to loved ones within the precincts of court here. It was a tug of war. The prisons authorities here were too harsh. They were too harsh. Very restrictive. Even after the court order had been given, issued, that we should have that right or opportunity to interface or interact with the accused persons. And shortly after that interaction, some members of the public were arrested, or actually were kidnapped from the precincts of court. This were Katongo Leuma and Kamira Abdul. They were picked by plainclothes operatives who could not be easily identified. At the very best, I can describe them as goons, because they were here, they were not in uniform, they could not identify themselves, and the reason why they were harassing people here, they picked and whisked them away. So, Your Worship, we pray that you take charge of the court premises so that members of the public who have a right to participate in the court proceedings here, to witness the court proceedings, to enjoy their rights without any undue interference or harassment or persecution. And I'm sure, Your Worship, even as we are seated here, same operatives are within the precincts of court, are within actually the courtroom. And finally, Your Worship, here, there was again a scene in this court. There was a scene here where members of, because he belongs to a Protestant political party, and he's a national leader, and there are people who are interested in these proceedings and want to attend. But this kind of treatment is making it difficult for people to be here to witness the court proceedings. And I was telling you this morning, there was a scuffle, there was a scene here as security operatives were unleashing terror and brutality against law-abiding citizens who are here to witness court proceedings. We therefore pray that your worship will be pleased to issue directives and orders that will grant protection of the rights of members of the public who have got a right to be here. We do so pray your worship. And again for the record, so that
emphasize what my senior leader has said, especially the concept of fair trial and the state's calculation to exclude the lead lawyer of Besigye and Butare, Honorable Karua Martha, Senior Counsel. It is illegal and will violate the right to fair trial contrary to Article 28, Clause 1, as well as Clause 3, paragraphs D and C. Your Honor, you are not, the law does not allow you to preside over a trial that violates the fair hearing of the accused. And we are making this complaint not only pursuant to the Constitution, but also the relevant sections of the Human Rights Act, namely sections 7 and 11. But because, Your Honor, this is a non-derogable right under Article 44, paragraph C, I think this court should be pleased to refer this matter to the High Court to pronounce itself on whether we can proceed without the lead lawyer of Besigye and Butare, so that this court can be guided on similar gimmicks, or repressive gimmicks by the state. May this be the last time. Yes. So that this honorable court can be guided on how to handle similar gimmicks by the state, designed to choose lawyers for their choosing. By orchestrating ambushes in forms of impromptu trials, impromptu appearances, court appearances like this one. This is an impromptu court appearance because even the lawyers in Uganda, some of them are still responding to this production warrant. Some of them, I had to call them and they were asking, oblivious of this court proceeding. So, in order to enforce Article 28, we are praying that this matter be referred to the High Court pursuant to the Human Rights Enforcement Act, sections 7 and 11, so that this fair hearing, this egregious fair hearing infraction by the state is addressed once and for all, because it is not the first time that the state of Uganda has tried to technically, but of course, progressively exclude Honorable Martha Karua from representing her clients in Uganda. The first initial attempts were to deny her a PC. The third was to delay it. The last time she got it, she represented it when they appeared for the first time, and now when she needed to appear and beg and implore this court last time, because she should be the one speaking, I shouldn't even be doing this speaking. The state claimed that it would not be here the state claimed in open court that they would not have any time this week.
But I think Your Worship, this is another thing to address by Senior Counsel.
Let him submit.
And then-
Let him submit.
My Lord, I will rest that point here and emphasize the second point of we are not safe in this court for you, both as lawyers and as members of the public who follow these proceedings. We need your protection from goons, some of whom are in court now, as you write, Your Honor. In that corner, some of them are there, some are in that corner. So, their unapproved conduct, Your Honor, includes after court arresting some of these people here. Their unapproved ignominious conduct includes arresting members of the public from here. They don't even wait to get out of court premises. They arrest Ugandans in court premises. It's about time judicially protected Ugandans, because courts are sanctuaries of justice. They are not scenes of arrest. They are not torture chambers. But even this morning, there were blows in this court before you started, before court started, because there are some fools who believe that they can come to court and not be filmed.
Don't use that language.
Most obliged. There are some ill-educated persons, Your Honor, who are oblivious and ignorant about the right to a public hearing. They think that they can be here and be protected from the camera without a court order. It is that level of ignorance that we have to confront every time we come to this court. Once again, that atmosphere is not safe, and we need the express protection of this court, because that does not require high court. It's not the, it is something that the court can use its inherent power to defend the public.
On the question of the state moving this honorable court to secure a production warrant, that there is a letter on record. It's gross unprofessional for one to write to court and will not share a copy of the communication you have filed on record with the opposite side. Very unprofessional. Up to now, up to this particular moment, Your Worship, we have not been given, we have not been favored with a copy of that letter. That shouldn't be taken lightly. And it's not a favor. It's a right that whatever anything you put on record, serve a copy on the opposite side. That's a command of the law. So we are really taken aback by that submission. It shouldn't have come from the chief state attorney, that they've moved the court and they never served us. It's an absurdity, Your Worship. Your Worship, he insinuated that indeed actually they had no objection to the adjournment of this matter this week. Actually, that they were in agreement with our prayer that this matter be fixed either yesterday or today. I hope he is also in agreement with the reason why we moved the court to have it heard today. Because the reason we wanted this matter to be entertained yesterday or today is on record, well captured on record. To give effect to the letter and spirit of Article 23, which dictates that once an accused person has been on remand for a period of 180 days, the next course of action will be mandatory bail. So if that is the reason we are here and is in agreement with that, then we have no problem. If we are here for a different reason, and that he moved the court to make other prayers, we have issues with that. If the court was, this session is about that application, that the accused person is be released, it's because they have spent more than 6 months on remand. And the command of Article 23 is very clear, read together with Section 76 of the MCA. Your Worship, if I may, for the record purposes, read this section 76, restriction on period of pre-trial remand. If an accused person has been remanded in custody before his or her trial commences,
Your Worship, before my